Hey, everybody. Thank you all for joining us today. It is time to go ahead and get started. My name is Andy Cole, and I'm the Pro Bono Coordinator at West Tennessee Legal Services. This is our 2023 annual ethics seminar. Everyone should have received in their email with the link to this, they should have received a link to the form to complete for CLE credit, as well as the materials, and I'll be updating those as I get more from everyone. But I will go ahead and turn it over to Lewis to get started for us.
Good afternoon, everybody. We had a deposition in our conference room where the video conference system is this morning. So you got me on my laptop here, and I'm sorry about those rays of light that are coming down through my screen, but apparently I can't do anything about that. Well, I turned the light off, and I'm gonna let some sunlight in here, but you'll see that half my face is dark. So let me turn around just a little bit. Sorry about this. Nope, that won't work either. Okay, well, sorry, looks like we're going to have to deal with the rays. You don't really want to look at me anyway. It's good to be back. Thank you for coming this afternoon. As I do sometimes, I'm going to talk about something that's a little broader and has a historical aspect. This is my time of the year when the West Tennessee Legal Services seminar rolls around to do something that I think of as fun. We've done a couple of things in the past. Last year was a little bit more mundane with the multi-jurisdictional practice, but we've done a couple of things in the past that were a little broader than that. And I want to do that again this year. We're going to talk about an episode in American history, which I think is kind of timely too, given everything that's going on right now. There are a lot of arguments about free speech, and here's an episode that involved a bunch of lawyers and a Supreme Court judge from early in the Republic, and you'll be able to see what happened, and maybe we'll have a little bit of time. We'll have a little bit of a few things to reflect on at the end of this presentation. So it's called Politics, Free Speech, and the Practice of Law, some aspects of professional responsibility in a democratic republic. I talk about it like that because the hold on just a sec. Here we go. So we think about the First Amendment as being, I think, relatively absolute. There's a copy of the enrolled version of the first 10 amendments as they were passed, and so you look back, it was ratified December 15, 1791. It had 10 articles that became amendments 1 through 10 to the Constitution. And the preamble to it, which we don't think about that often, had this language in it that said the conventions of a number of the states wanted to or had expressed a desire to have some curbs on the national government, and so they suggested these 10 limitations essentially on the power of the federal government. And you get the First Amendment, which is the religion, speech, and religion, speech, press, and assembly. And if you follow constitutional law at all, you know that textualism has become the byword of the day on both the left side of the aisle and the right side of the aisle in the U.S. Supreme Court. Everybody's arguing about textualism. And so I don't know how anything could be more clear textually than the speech and press amendments the speech and press clauses of the First Amendment. Congress shall make no law abridging the freedom of speech or of the press. That's what it says. It's pretty doggone clear. And yet, I say, at the very beginning of the Republic, just some 7 years after the First Amendment had been ratified by the states, Congress passed 3 statutes in 1797 and and President Adams signed them into law in June and July 1798. These 3 statutes are collectively known as the Alien and Sedition Acts of 1798. They comprise 3 statutes: the Alien Act, which essentially gave the president the authority to deport anyone who was not a citizen of the United States, who the president felt like was harming the United States. There was a real there was a real dispute in the early republic about whether or not to support the French after the French Revolution, and so the President Adams and the Federalists generally were not in favor of that. Thomas Jefferson, as everybody well knows, and the Jeffersonian Republicans, or the Democratic Republicans as they were sometimes called, generally were more in favor of the French. And the French had been, some people thought, meddling in the affairs of the United States. And so this Congress, which was controlled in 1797 and 1798 by the Federalists, the party of President Adams, passed these 3 statutes: the Alien Act, the Alien Enemies Act, and the Sedition Act. I don't think anything is more clear to me than that the Sedition Act was absolutely designed to silence the opponents of President Adams and the Federalist Party. You'll see, we're going to look at the text of it in just a moment. But the House was about evenly divided. The Federalists were a little more in control of the Senate, but the House was about evenly divided, and the 3 statutes passed 44-41. This is a quote I love from a guy named John Allen, who, by the way, is a lawyer and a future member of the Connecticut Supreme Court. Liberty of the press and of opinion is calculated to destroy all confidence between man and man. So they not only did the Federalists not value freedom of the press, but they actually thought it was deleterious to the health of the republic. And you'll see in just a few minutes when we start talking about the things that actually got said and done that led to a conviction under the Sedition Act, that it was pure politics, really just a normal partisanship that got this man convicted and sent to prison for 9 months. This guy named Callender. There's a copy, and I made it a little big. Sorry about that. That's a copy of the Sedition Act. Let me get over to this is the text of it. If any person shall write, print, utter, or publish. Now look at that. Write, print, utter, or publish, or shall cause to be written, printed, uttered, or published false. And false statements probably are not not protected, but it also says scandalous and malicious writing or writings against the government of the United States or either house of Congress. I think most of the people in the United States would be convicted under this statute today, because most of the people I know have said something scandalous or malicious about one or both houses of the U.S. Congress or the president, with the intent to defame the government or either house of the Congress or the president and bring them or either of them into contempt or disrepute. You look at that, it is very, very difficult to square that with the plain text of the First Amendment. I mean, it is basically saying that it's essentially saying that you can't be critical of Congress, of either house of Congress or the president, which basically means that it's become illegal. to criticize the government of the United States. And you think that could never have happened here, but in fact, it did happen here. It happened in the 1798, 1797, 98 when this Sedition Act was passed. And then the next thing you might want to say is that, in fact, even if it was passed, it would never have been enforced. But in fact, in the time remaining in office that the Federalist Party had, there was an effort to prosecute a couple of people, the most notable of which was a guy named James Callender, and we're going to get to the case of U.S. versus Callender in just a moment. I put the Section 3 out of the statute in there because I wanted you to see that the statute itself said an interesting thing, which we don't need to trace out here, but which I just wanted you to see as having been the law at the time the statute was passed. And it said, the jury who shall try the case shall have a right to determine the law and the fact under the direction of the court, as in other cases. So here's the man that we're going to talk about for most of the rest of the time that we're here today. That's a gentleman named John Thompson. That's the way it's spelled in the reporter right there with the P. But in most of the biographical data that I looked at for preparing this presentation, it actually was spelled with the P. I mean, yes, John Thompson, but in the case reporter, it's spelled with no P. Excuse me, I got that backwards. In the case reporter, it's spelled with the P, and in most of the biographical data I reviewed, it's spelled with no P. That's a picture of Mr. Callender right there. He was a newspaper editor and kind of what I'd call a roustabout. He was constantly trying to cause trouble in the early republic, and he was a dedicated Jeffersonian Republican. And so he finds himself in Richmond in 1799 and 1800. I've given you the site there for the online report. These are classic old school case law reports where if you can, I guess you can't see what I've got here, but I printed it out from Wharton State Trials. It summarizes the arguments that were made. It talks about a request for continuance that was made at the beginning of the trial. There's an objection to the admissibility of the evidence, which is that Callender's lawyers objected to the book or the pamphlet being entered into evidence. And then another interesting thing is that, of course, this is under the very early first version of the Judiciary Act, and so there are no district courts, and there are no separate circuit judges. Essentially, there's one level of appeal to the United States Supreme Court, and the United States Supreme Court judges, each one of them is assigned to ride the circuit in the different geographical areas of the country. I don't know if you remember or not, but the year that we talked about, maybe 2 years ago, perhaps 3, that we talked about the ex parte Merryman case and Lincoln's suspension of the writ of habeas corpus during the first couple of years of the Civil War. You may recall that Chief Justice Taney was sitting as a circuit judge at Maryland when the decision was issued in ex parte Merryman about releasing John Merryman from confinement at Fort McHenry. The situation in which Lincoln refused to do that essentially told the marshal of the Supreme Court to bring whatever army he could to free Merryman from confinement at Fort McHenry. And of course, that wasn't done. but this is the way that the Supreme Court was structured in these days. It was actually not just the Supreme Court, it was the way the entire judiciary was structured in the United States. And so this guy named Samuel Chase, who we're going to talk about quite a bit, he was an associate justice of the Supreme Court. He was also the trial judge in this U.S. versus Callender case. And I copied part of the indictment there because I wanted to see it. Charged Mr. Callender with maliciously intending to defame the President of the United States and to bring him into contempt or I left out the word, looks like, or disrepute, and to excite the hatred of the good people of the United States against him. Callender did wickedly and maliciously write, print, utter, and publish a false, scandalous, and malicious writing against the President of the United States. I copied that from an OCR version. It looks like it's got a couple of typos in it, so you'll have to forgive me for that part of it. And here's the language, which is, I think, is also pretty interesting. This is the excerpt that was included in the indictment. The reign of Mr. Adams has been one of continued tempest of malignant passions. As president, he has never opened his lips or lifted his pen without threatening and scolding. The grand object of his administration has been to exasperate the rage of the contending parties, to calumniate and destroy every man who differs from his opinions. Mr. Adams has labored, and with melancholy success, to break up the bonds of social affection, and under the ruins of confidence and friendship, to extinguish the only gleam of happiness that glimmers through the dark and despicable farce of life. So Callender basically is accusing President Adams of ruining the world. Not only that, look at that. I left the bottom part of that in there because I wanted you to see that Callender even attacked George Washington, which I don't think anybody would even ever dream of doing now. Washington has become sort of object of veneration. But at that time, Callender attacked even Washington, and remember he was ensconced at Richmond when all of this happened in Virginia. He had been in the North in Vermont, but at the time that this happened and this pamphlet was published, he was in Richmond. So here's what happens with Mr. Callender. There's a trial, a jury trial, and essentially they read this. The case report relates that they read this book into the record. What I showed you just a minute ago. This language right here, and there are about two more paragraphs, and then they basically enter the whole book into evidence, or the small book, the pamphlet-sized book, and Mr. Callender is found guilty by the jury. The Justice Chase imposes a sentence of a fine of $200. Just for comparison purposes, I wanted you to know that would be like, I thought it would be like $50,000 today, but adjusted for inflation from 1798, 99, excuse me, until today would be only about $4,800. And then he was sentenced to prison for 9 months and actually served the entire sentence in prison. So he did not get out, and he was not pardoned by the Jeffersonians in the next administration, which we're going to talk about in just a second. He died by a drowning accident in Richmond in 1803. So this is the second part of the story that I think is also relevant. The first, just to go back over a little bit, the first part of it is, look how contingent the operation of the First Amendment was in the early republic. This is only, the states had specifically requested the consideration of this Bill of Rights to limit the power of the federal government. And one of the important ways in which that was limited was by the First Amendment, which contains several clauses. It contains the anti-establishment clause, which says the government can't or Congress can't establish a religion. It also says that Congress can't make laws that infringe on the free exercise of religion. And then it says Congress can't make laws that abridge the freedom of speech or the freedom of the press, or the right of the people to peaceably assemble for redress of their grievances. So essentially it contains these 5 things. I don't know how it could be any more clear. I don't think there's another provision in the Constitution that is as clear. Leave out the establishment or the anti-establishment clause. Leave out the anti-establishment clause and the free exercise clause, because those have been the subject of endless debate. But just think about the second clause, which says Congress shall make no law to abridge the freedom of speech or the freedom of the press. Nothing textually in the English language, I don't know how anything could be any more clear than that. So that, and yet, even though that happened in the heat of a partisan moment, which was this really highly contested period in American history from 1797-98 on over to the election of 1800, which is one of the most hotly contested and disputed elections that have ever occurred in the history of the United States. You will remember that it was Adams for the Federalists and Jefferson for the Jeffersonians or for the Democratic Republicans in the presidential election of 1800, and it was essentially a tie in the Electoral College. So the election of 1800 went to the House of Representatives, which, because of the way that things happened at that time, the House that voted on the presidential election, in other words, the House that heard the dispute about the presidential election of 1800, was basically the House that had been elected and was still in office. Everything didn't happen so quickly because travel was so hard that the House who voted on this was the one that had been in place before. So it was much more closely divided. In the elections of 1800, Jefferson came to be elected by this dispute resolution system that existed for the House of Representatives to settle a failure of either party to gain a majority in the Electoral College, and the Federalist, the Jeffersonian Republicans took a majority in the House, but that House where they had a clear majority wouldn't be seated until later in the year of 1801. So the election happened in late 1800. The dispute is resolved in early 1800. It's resolved by the old House that had existed, and eventually Jefferson does prevail, and later on the new House is seated. But so one of the things that happened then, in a couple of years later, you can see everything's not as fast as it was. Everything's not as fast then as it is now. One of the things that happened is the Justice Samuel Chase, who presided at the trial of Mr. Callender, was impeached by the House of Representatives in 1804 on a pretty much a party line vote. And just for reference purposes, that's only the third impeachment in the history of the Republic. So there had been 2 prior to this. and he's the only Supreme Court justice who's been impeached, and it was only the third impeachment in the history of the Republic. He was tried by the Senate in late 1804 and 1805. Part of the there were nine charges that were levied against Samuel Chase, and essentially all of the charges that were levied against Samuel Chase were charges that were related to him deciding cases or acting in cases in a way that demonstrated political partisanship in the exercise of his judicial office in favor of the Federalists. So he was accused not of any financial impropriety, not of any outside high crime or misdemeanor, but essentially he was accused of acting in a judicial capacity in a way that demonstrated too much partisanship, and so he was tried. By the time he was tried, the Jeffersonian Republicans, or the Democratic Republicans, however you choose to denominate them, not only had a majority in the House, but they had a majority in the Senate. He was acquitted on all 9 charges, including the charge that one of the charges was related to him seating a juror who the people who impeached him said should never have been seated in the Callender case, and so they made that charge, and they alleged in the articles of impeachment that the outcome would have been different in the Callender case if Chase had not seated this juror that he shouldn't have seated. He was acquitted, but on 8 of the 9 counts, a majority of the Senate actually voted to convict him, but it was not the 2/3 required to convict and remove him from office. And so I think that's an interesting bookend to U.S. versus Callender, that the presiding judge of that was then impeached by the House of Representatives for exercising his office in a partisan way, which is exactly what the statute was designed to do. It's hard to fault a Supreme Court judge in one way for carrying into effect an improper statute. That's a real example, maybe, of where you've got this real tension between the clear text of the First Amendment. No question, we didn't have incorporation then. That wasn't to come for another 150 years or 140 years. But it was a statute that had been passed by Congress. So there was no question that even in those days, the First Amendment applied. No question that it was a result of federal action, and really no question that it was a direct effort to abridge the freedom of speech. It was a statute which criminalized certain types of speech. In other words, types of speech. The funny thing is about the statute, I say funny thing is funny like an interesting thing. One of the most interesting thing about the statutes is that one of the clearest pieces of evidence that it was nothing more than a partisan attempt to control their political opponents is that the Federalists who wrote the statute made it sunset. It contained an expiration provision in 1801, which is to say that it expired automatically during the exact time frame that the change in political power would take place. So the people who passed this statute certainly demonstrate that they did not want to live under this statute, because by the time they went out of office and were what might have been subject to it, it was set to expire automatically. And so you get the Justice Chase. I always get him mixed up, by the way, with Salmon Chase, which is the man who was Lincoln's Treasury Secretary and then was a Supreme Court judge. But this guy's name is Samuel Chase. He was indicted and then acquitted in this impeachment. Excuse me, he was impeached and then acquitted in the impeachment trial in the Senate. So here, I think that historical episode has maybe three things that we ought to think about as lawyers, which is what this is what the point of it is, which is to get us to think about something, right? The updates that Bruce will give you are eminently useful. The discussion that Laura will provide is eminently useful, and we need to know those things because we need to make sure that we are compliant with the rules that govern us as lawyers. But that's not all there is to being a lawyer. Minimal compliance with those rules is not the only thing that there is to being a lawyer. And so we like to take this opportunity to look at these little historical vignettes that I've brought up about Merriman, about Joseph Hartinger, to think about the broader implications and the broader responsibilities of being a lawyer. Because I would like to suggest to you that there are a number of broader responsibilities, and we're going to look at those and try to tie this back into a couple of things that we have that we've talked about in the past. First of all, think about it this way, right? The world is not a perfect place. Obviously, this thing was a mistake, and I think everybody realized that it was a mistake. I think probably the Federalists realized it was a mistake when they were doing it because of exactly what I said to you, which is that they made the thing so that it expired by the time they would be out of power, so it could not be used against them. But sometimes mistakes have to be made. We have to try to minimize it, obviously, but we can't expect human affairs to be perfect. Nothing is. And sometimes we have to make these mistakes in order to be able to move forward. There is no question that this statute was an effort to silence political opponents. There's no question that the statute was overreaching. I don't even think anybody had a real question at the time that the statute violated the First Amendment. There was no Supreme Court decision after Mr. Callender's trial. I'm guessing that it just would have taken too long given the jail sentence. And by the time the trial was over and the sentence had been served out, the Democratic Republicans had won in the elections of 1800. And so Mr. Callender was expecting that he would be vindicated by the political process rather than by the judicial process. I think ultimately, some of you may know that Callender, one of the things that's famous about Callender is that after Thomas Jefferson refused to provide him federal employment, when the Jeffersonian Republicans won in the election of 1800, and then Thomas Jefferson refused to provide Mr. Callender with federal employment that would have taken care of him, he turned on Jefferson, and Mr. Callender was the first person to make these public allegations in a Richmond newspaper about Thomas Jefferson's relationship, which we all now know to be 100% true, about his relationship with people that who were held by him as property at that time. And so these allegations came out by Mr. Callender, and after Jefferson refused to provide him employment. And of course, at the time, it was easy for people to say that they weren't going to pay any attention to that. But of course, we now know that to be 100% are correct. As much as you can know any historical fact, I think that's been a fact that's been demonstrated to be virtually unassailable, that these terrible things happen. And Mr. Callender was the first person who brought those up. But before he had a chance to do anything else, he died in this drowning accident in Richmond in 803. And the next thing is that, you know, the partisan politics is greedy, and it can be ugly and even harmful at times. I don't want to get into a discussion of actual political issues at the moment, but I think everybody probably can see that we're at one of those places in history where the process is demonstrating all of its grit and all of its ugliness right now. And one of the reasons I picked out this particular episode, this particular vignette to talk about, is because I think it helps us to see that, yes, this goes on. And yes, that there's a little bit of context here. This is the kind of thing that's been going on since the beginning of our republic. Not that we don't want to avoid it, and not that we shouldn't do everything we can to try to avoid it, but at least put it in a little bit of perspective. As ugly and gritty and harmful as we think the partisan process is, yes, and it is sometimes, it does happen, and we do get over it. And it, at least, as I say there, provides this kind of competitive environment for the process to continue. And when one side overreaches, at least this chance exists for the other side to make up for it through the process. And that is that, as you saw, yes, the Federalists overreached terribly with this Sedition Act statute and the Alien Act and the Alien Enemies Act. But even though they overreached, the corrective came at the election of 1800, and the Federalists were thrown out of office. Now, the end of the story is not always that nice and tied up with a bow. I get that. Sometimes it takes longer. Sometimes people are even more harmed than they are. But there's a lesson here, I think, for lawyers, which is that we live our lives in this dispute resolution system. And even if you're a transactional lawyer, it is a dispute resolution system, because being a transactional lawyer is about helping people to hedge their bets against a dispute by clarifying the relationship to begin with. Those of us who live most of our existence in the litigation system are maybe more acutely aware of this. But I was in a little presentation with the former clerk of the Supreme Court one time about 15 years ago, and he said, "Can anybody tell me what is our court system? What is it at bottom?" And I said, maybe the answer you're looking for is it's just a dispute resolution system. When people come into my office and want to talk to me about a lawsuit, I say, look, first of all, figure out if there's another way to do this, because I'm going to tell you on the front end that litigation is expensive. It's maybe gotten too expensive, and there may be things we could do about, as lawyers, structural improvements that we could make overall that would help to reduce the expense, and maybe in some sense the complexity, maybe in some aspects the complexity. But there are probably things we could do to reduce the expense of it. One might suggest that it's not in our interest to make it any less expensive than it already is, but that may be a topic for another day. But there's a direct parallel between this gritty world of partisan politics and the system in which we live our lives, which is this dispute resolution system, because it's exactly the same, right? We don't always win when our clients are correct. The process that we have for court does not guarantee that the side that is correct will prevail in every single instance. Now, the second thing I tell people, if they don't walk back out the door after I tell them to find some other way to resolve their dispute because the litigation system is very expensive, the second thing that I tell people is, look, you're not going to get what you think of as the correct result in every case. There's no human system that could come up with the correct result in every case, just like elections don't come up with the correct result in every case. The best person, the most qualified person, the person who would render the best service to the to the office, it doesn't that person doesn't prevail every time in the election. And so you have to you can't expect that to happen, and you can't expect that to happen every time in the dispute resolution in which we live our lives. If we do our jobs carefully and we do our jobs competently, then it increases the likelihood that this thing will work out in the best way possible. But it's not a perfect system. No human system is perfect. And the more we do to explain to people, the more we do to live our lives in a way that that manifests that idea to people, rather than telling them that the system is crooked. And I know sometimes it is, I get that, but or the judge is in favor of the other side, or the jurors are biased somehow. The fact of the matter is, this is a human system, this dispute resolution system that we've got. The election system is a human system, and there's always an opportunity for things to work out with less than an optimal outcome when you've got human beings involved, for all the reasons that we all know, because sometimes people's interest calls them to think about a problem in one way that might not be the exactly objective way that we would like them to think about it, whether it be a vote that they're about to cast, or in an election, or a vote that they're about to cast in a jury trial if they're back there in that room. But most of the time, in fact, more of the time than anything else that any human being has ever come up with, this system, this partisan system that we've got for electing people, and this dispute resolution that we've got for trying to keep people from shooting each other, because at bottom, that's what it is, right? It's a substitute. Our lives are to be a facilitator for people, to a system that offers an alternative to violence. If they have a dispute with their neighbor, and when I was a young man, I worked at a funeral home for about 2.5 years, and one day after school, I showed up for my job, and they told me to go to the VA hospital and pick up someone who had died and bring it back to the funeral home to be embalmed, and then go through the process. And so off I go to the VA hospital in Johnson City, which is about 45 miles from Rogersville. So I drove over there. I got there. The medical examiner was just finishing up an autopsy of the person, and so I had to sit and wait. And then when I waited, the medical examiner told me an interesting story. He said, "Young man, I want to tell you what happened." I was 16 or 17 years old. He said, "I want to tell you what happened in this case. This man right here died of a gunshot wound." And so he and his neighbor had been his neighbor had been building a fence. This gentleman thought that the fence was over on his property line. He and his neighbor got into a shouting argument. They both went back in their houses and got guns. Then they came back out and shot at each other. The gentleman who was dead had shot at his neighbor with a .32 caliber revolver and had hit him in the stomach, and that gentleman was hospitalized. the gentleman who was in the hospital had shot at his neighbor with one of the little 25 automatics, and he'd shot him in the left shoulder, and the bullet ricocheted off his left shoulder bone and went down into his heart and killed him. And so he was deceased, and I was picking up this person to take them home, and the medical examiner said, "Let that." I didn't know I was going to be a lawyer at that time, but the guy said, "Let that be a lesson to you about how to resolve a dispute if you have one with your neighbor." It's a good lesson. Right. And it made an impact on me that I have not forgotten all these years later. In fact, I think about that episode often because to me, it's the quintessence of our professional lives. That episode is the quintessence of our professional lives. We are the facilitators for this system of dispute resolution that has as its really stark alternative people walking out into their yards with pistols and shooting at each other. That, and it doesn't get reduced to that in every, in every case. It doesn't get reduced to that. You may remember that there was an episode where a senator, the guy Paul from Kentucky, he and his neighbor had some dispute over, I don't know, the way the lawn was mowed or something, and the guy ended up just knocking him down and injuring him pretty seriously. So they didn't shoot at each other, but it doesn't always end up with somebody dead. But the point is, this system is an alternative to violence, and it's so complicated, right? We can get so wrapped up in the technicalities of it. I sit with the rules of civil procedure. I sit with the case law and the statutes that apply to any lawsuit that I file. I sit with these things and try to figure out the technical aspects of my case. Those things are incumbent upon us to do. We've got to be competent in that technical sort of way in order to comply with our professional responsibility. But we also have to take into account this broader context in which this happens. And in the back of our minds, not because it's going to happen in every case, but because it helps us to maintain a perspective that is invaluable to our clients. If we can put this thing in the broader context, if you can look at it and say, yes, when you cut out all this other stuff that you have to think about, when you cut out all the things that all these deadlines I have to think about every day, all these changes in case law that I have to think about every day, the way in which statutes are changing, the way in which the rules are changing, meeting the procedural requirements of getting these things done. When you cut all those things out, we are immersed in a system that at its core is a replacement for violence. And we when we lose sight of that, right, it means that we lose a little bit of perspective on what the value of this is, because the true value of what we do is enabling people to have a forum, a method, a process for resolving their disputes that doesn't require them to engage in violence against each other. And that's a useful thing to think about. I think it's a useful thing to think about, especially where we come to these places in the history of our country where it seems more or less likely that violence might occur. And I don't think I don't think on the long view of American history that it's any worse at the moment than it has been at different times throughout the history of our country, because we've got these episodes, one of which we've just looked at, but there are others of which we could look at. I think the one with Lincoln is a pretty good one to think about, right? The president of the United States thumbing his nose at the Chief Justice of the U.S. Supreme Court, right? And in that case, violence was already underway. And so you kind of get a stark reminder of what happens when we have to do that. 650,000 to 700,000 people died in that exercise. And at the end of the day, the change that we got in our country was definitely worth it. Um, you know, and was that the only way through it? It looked like it was at the time. So I don't say that there's never a time when violence is justified, because there are going to come those times when it's the only choice. But we have to be the people who try to encourage other people to make those times when it's the only choice very few and very far between. We're the grease that keeps that from happening, right? And lest you think that my header in the clouds, Aeschylus thought Socrates was in the clouds. We're the face of the legal system to most people, because we're the person that they're going to have the most interaction with in their interface with this system. And so I tried to end this thing by a little inspirational slide. Professional responsibility is broader than just the rules of professional conduct, right? Of course, we have to comply with the rules of professional conduct, and that's why we come to these seminars. That's why we get ready and prepare these seminars. It's why we think about these things, because there are, just like prosecuting a lawsuit on behalf of somebody involves attention to the detail of all these procedural issues that go into making the lawsuit come off correctly. By come off correctly, I mean getting through the process and getting to a substantive result in the process. I don't mean coming off correctly, but necessarily meaning that we win in every particular case. But I think lawyer citizens, we call them here on this slide, have a special responsibility to understand and uphold the rule of law. Now, I know that there's a lot of jaw jacking going on about the rule of law these days, and partisan actors are both making what I call mutual bilateral claims that the other side is violating the rule of law. I think the rule of law is, really actually a fairly simple concept. It's not that it's a concept that would say that the process, it's mostly a procedural claim, right? That the dispute is resolved according to rules that are in existence prior to the time that the dispute, the procedural rules are in place, and it's decided according to some more or less neutral standard. Not any standard is completely neutral. That's what we get with human actors being involved in the system. There's no place from which 100% objectivity can be obtained, but we can have these procedural safeguards in place to try to make it as objective as possible, and with as much attention to the substantive rules that apply to that particular dispute as possible. We can't ask for a result that can't happen when human beings are involved in it, but we can ask for a result that takes respect of the pre-existing procedural rules and the substantive rules that govern whatever the area is where the dispute occurs. And I take care to say, right, this doesn't mean that lawyers are smarter or better or superior to other citizens, that lawyer citizens are better citizens. It doesn't mean that. It just means that because of the place where we live our lives, because of the positional situation that all of us are in, the practice of law comes with responsibility to understand and live out respect for the rule of law, right? We have to be the living examples of how that works out to people. And when that's part of our professional responsibility, and it's more difficult than in some respects than following just the technical rules of the rules of professional conduct, because it's not a bright line rule that we necessarily can just check the block and adhere to. And so it's a more difficult, at the risk of being run off, it's it's an existential rule, right? Not a not a piece of not a piece of not a propositional rule. A propositional rule is that that a claim must be filed within a certain period of time, or it's barred by the limitation period. That's a propositional rule. It's a fairly straightforward proposition. This is not a propositional rule. It's a rule that we have to live every day. And there are tiny ways in which we can do this. In other words, demonstrating respect for the process rather than than claiming that something nefarious is going on every time we don't get exactly the result that we like to get. And I know good and well that that's a big temptation. And I'm just saying, because of our position in the system, not because we're smarter than other people, not because we're superior to other people, because we're not. As citizens, we're not. The sort of idea underlying our country is that each and every citizen occupies the same spot with respect to governance and with respect to the law. And so we're not claiming, and sometimes in the past, I think lawyers have claimed this, but we're not claiming that it makes us smarter or better than other people. Just that, because of our position, every one of us, we have this kind of responsibility to live this out. And there I wrote down what I said, to the maximum extent possible for human affairs. This is this is not a precisely defined standard, but it is an absolute standard, right? It means that we absolutely must do it in every case, even though the definition of it is not precise. And that makes it more difficult because it makes it there's no simple heuristic that will guide you in every case about what the rule of law demands. But it is absolute that it must be followed to the maximum extent possible in every case. Matters are decided on the merits using process rules that looks like I forgot to type that existed prior to the time the dispute arose in the end of that slide, but you get the idea since I've already said it. So I've got a couple more minutes here. I just wanted to tie this back into the connections because to me, in my mind, it's directly connected to other things that we've talked about, right? Remember Josef Hartinger, the Bavarian state prosecutor I talked about, I once again recommend to you Timothy Ryland's excellent book, Hitler's First Victims. Hitler's First Victims. The author's name is Timothy Ryland. I recommend that again, as I did before when I talked for nearly the whole hour about Josef Hartinger. He's this Bavarian state prosecutor who opposed the practices at Dachau concentration camp. For those of you who have forgotten, and I hope nobody has, Dachau was the first Nazi concentration camp where a lot of political opponents were interned, not necessarily a racial or ethnic camp, but there were a lot of Jewish people who were interned there because there were a number of German communists who were Jewish, and that was what it started out. Hartinger tried to prosecute people for murdering these inmates, detainees at Dachau in 33 and 34. He was unsuccessful in doing that, lost his job as a prosecutor, but he preserved the records of the murders there that the Allies then turned around and used at Nuremberg. And that is kind of the the epitome of what I'm talking about, right? He couldn't get a perfect result. He couldn't stop the murders. He couldn't indict right then the people who were responsible for those murders, but he did what he could up to the point of losing his job. He got transferred to a less desirable position in the Bavarian state apparatus, and he preserved the evidence that was later found by an army intelligence team in his office at the Bavarian State Ministry of Justice, and then was used against the Nazis at Nuremberg, at the IMT, the big trial at Nuremberg. And then John Adams, right? The very person who signed into law the Sedition Act of 1798, President John Adams. We spent one of our years, we spent talking about John Adams, who was a prominent lawyer in Boston when the Boston Massacre occurred. Remember what happened? Probably what happened is that there was a protest and some British soldiers were there and somebody hit one of them with maybe an ice ball or a snowball, and there was suddenly a volley of firing by the British soldiers, and people were killed. And these British soldiers got put on trial for murder. And John Adams defended. I think if I remember correctly, he defended 7 of the 8, and he is all of his clients but one were acquitted in that trial. Hugely unpopular thing. And you look at that again, like Hartinger, John Adams is kind of the epitome of the human condition. He's so brave and courageous when this massacre happens. He's so dedicated to maintaining the rule of law that he volunteers to represent these British soldiers in this horrible environment in which people were very upset with him. And yet, later on he signs this Sedition Act. It just goes to show us that none of us, good as we are perfect, and we have to kind of hold ourselves to the standard of doing right. But we also have to realize for ourselves and especially for our opponents that no one is perfect, right? Nobody is perfect, and so we can't expect something that people can't do. And then the final one, is Abraham Lincoln, and we talked maybe 2 years ago about ex parte merriment. To me, that's one of Lincoln lived his life in the legal system. He's the lawyer who's been in private practice longer than anybody, the lawyer president who was in private practice longer than anybody. Lincoln was an outstanding lawyer. And he wrote a lot of things, some of which I've shared with you in prior years about adherence to the rule of law and respect for law. But yet, when he became the president, he realized that law is a it's a piece of a system, and along the continuum, it works up to a certain point. But sometimes, when the violence has started, that causes the calculus to be a little bit different. And I think we learned a little bit about that from looking at the ex parte Merriman case. Okay, so I took 1 minute longer than I was supposed to. Andy, I'm sorry. Bruce or Laura, whoever's next, I'm sorry I took up your time. I appreciate you listening. I appreciate you letting me reflect on some things that I think are useful for us to think about. And I'm looking forward to the rest of the program. Thank you. And everybody have a good afternoon.
Great. Thanks so much, Lewis. Bruce, you should be able to.
Good afternoon, Bruce.
Good afternoon, Lewis.
How are you, my friend?
I'm well.
Good. I'm looking forward to your presentation.
I hope you chime in when you are so inclined.
I'm going to mute myself.
Oh my gosh, I'm in trouble now. Sorry, Andy.
You should be able to go ahead, Bruce. If you want to share your screen or do anything, you should be able to do that, but you're good to go.
What about the handout? Can we display that or not?
Yeah, you should be able to if you pull it up on your screen and then click the share screen button. It should be able to pull up, and you can pull up where on the handout you want to be.
Hey, Bruce, what I brought, it took me a second, but I brought it up on my screen, and then you press that green share screen button, and then it comes up with a list of windows that you've got open, and it'll let you choose the one that's got your handout in it.
Thank you. Okay.
There we go. We can see it.
Okay, very good. Now to physically get it on the same. Okay, same monitor. Okay. All right.
Now we can't see it anymore because you pulled it.
Of course not.
Yeah.
Okay.
You have it showing that one screen wherever it was. Yeah.
Okay. Very
Uh,
good. All right. And so I can move it. Yeah. I'm moving it, and I take it that that's doing that. Okay. All right. Um, Good afternoon. My name is Bruce Smith. I'm a member of Apperson Crump in Memphis. I'm our ethics officer. I'm a former hearing panel member from way back in the day. And Lewis and I have taught West Tennessee Legal Services annual ethics seminar. We do it as practical legal ethics. So there's a lot of material to cover and not enough time in which to hit on every topic. Um, hope you. So the handout is intended to be a desk guide where if you think of something or you want to take a quick look, this will get you. It will get you some information. I have all of these materials. I'm glad to send them to any of them to anyone who wants. I'm also provided my contact information. If you have a question or a scenario that you'd like to review, don't hesitate, contact me, call me or shoot me an email. I'm glad to discuss it with you. Starting off, advertising. There is an opinion that is not in your materials. It is Witherspoon Law Group. It's an important development in a saga that began several years ago. You may remember the tragic bus crash, school children that were killed, and a law firm and two of its staff came to Tennessee and literally found a way to get in funeral homes and get introduced to family members who were coming to make arrangements to bury their dead children. An opinion came out after we met last year. State of Tennessee, X. Rel. Slattery versus Witherspoon Law Group. It's an out-of-state law firm. And in Tennessee, we have a prohibition against contacting a potential client for a period of 30 days after a tragic event. The Attorney General Slattery brought suit under the Tennessee Consumer Protection Act and also under the unauthorized practice of law statute. There was a trial. A jury came back and assessed significant civil penalties against the defendants, and the Court of Appeals affirmed. Attorney-client privilege and breach of confidentiality. A reminder that there are problems on a regular basis about lawyers perhaps unintentionally, negligently disclosing confidential information in an affidavit filed with a motion to withdraw. The judges understand that when a lawyer is seeking leave to withdraw, that there are many things that lawyers cannot or should not say. A couple of years ago, we discussed a case where a lawyer was censured, and it was because filed a motion to withdraw, and the basis was that the client had lied to the lawyer. Of course, at the hearing, front and center is adversary counsel, who says, Your Honor, if it's a lie to the tribunal too. counsel needs to tell us what the lie was, and I want to depose the client. So again, judges understand, but don't disclose confidential information in seeking leave to withdraw. Artificial intelligence, not listed, but this in many ways, it is a predominant ethics topic right now. The artificial intelligence is being discussed in society. Then there are legal implications to artificial intelligence, and it is changing rapidly. There will be many more developments by fill in the blank next month, next spring, by the time this seminar reconvenes next year. The main thing to remember is that it's moving fast. There is very little guidance ethically on it, but that doesn't mean that the ethics issues don't exist. There's an article in from January this year. It's an AI startup that was called Do Not Pay. And in New York City, the idea was it was a way to contest traffic tickets. The idea was that the consumer would wear smart glasses, and in the courtroom, the AI bot would be able to hear what was happening, and would send messages to the consumer on what to say and how to argue through a small speaker. It relied on ChatGPT and DaVinci. The founder of the startup received many state bar warning letters. One state bar official said that several mentioned unauthorized practice of law. One of the letters said that in his or her state, that unauthorized practice of law was a criminal misdemeanor. So he stopped it. He did not roll it out, but he said this is what's coming, and frankly, the rules are outdated. But robot lawyers have another obstacle that they have to overcome, and that is that in federal court and in many state courts, recording audio is not permitted. But and that creates a problem because the chatbot relies upon information that it hears in order to develop the algorithms it uses to provide information back to the consumer. Around the same time, ChatGPT was asked 50 questions about the U.S. Supreme Court, and it got 21 of the 50 right. So there are kinks, that poor choice of term, that have to be worked out. There was a comment that said that ChatGPT at that time, and this was January, back in January of this year, when we were all young and foolish, and as far as artificial intelligence was concerned, that says that ChatGPT could not write a useful brief. So, attorney's fees, an important development. The ABA issued a formal opinion, number 505, on retainers. It's titled Fees Paid in Advance for Contemplated Services. If it were to become effective in Tennessee, it would have a profound effect on Tennessee practitioners. Remember that ABA formal opinions are not binding in Tennessee unless the Tennessee Supreme Court or the board adopts the ABA formal opinion. The question is, the question that this dives into is, can there be non-refundable retainers? This is a subject area that the rules of professional conduct of many states disagree. The ABA view, and the ABA view is essentially we don't like retainers. Everything is an advance payment, and advance payments can be refunded in whole or in part to the client who paid the advance payment. And essentially, if the Tennessee Supreme Court were to enforce or adopt ABA Formal Opinion 505, Tennessee lawyers would all be working on an hourly basis, or in contingent fee matters, a contingent fee basis. And again, the reason is that advance fees are unearned because they're for work that's to be performed in the future, and they remain unearned and hence refundable until the work is performed. In Tennessee, Rule 1.5F specifically acknowledges non-refundable fees. And comment 4 to the rule states that the obligation to return any portion of a fee does not apply if the lawyer charges a reasonable non-refundable fee. There is always a condition that the fee must be reasonable, regardless of the type of fee that it is. And courts routinely apportion fees when and determining that whether or not a refund in whole or in part is appropriate. A couple of practice pointers just as reminders. If you want to recover attorney's fees in the contract or written agreement has to use the magic words attorney's fees. Don't dance around it by saying costs, expenses of collection. Use the word attorney's fees. And again, the courts are increasingly looking at time records in awarding attorney's fees. There are some lawyers who keep time, we don't keep time records in doing real estate closings. We hear that often. We don't keep time records on contingent fee cases. Well, if it is a sizable closing, if it's really as much a transactional matter, you may want to consider keeping time records. The bankruptcy, a lawyer received a public censure. He filed 8 documents with the client's electronic signature. The local rules required that the attorney maintain an original signature for any document filed electronically. The lawyer didn't do that and received a public censure. That's the Fulton case. Candor toward the tribunal and communication with person represented by counsel are topics we discuss most years. They still maintain timely. Always consider whether, if something happens, whether there is a duty to disclose to the tribunal, and better practice is not to cut corners with a tribunal, hoping that a problem can be circumvented or skated past. Conflicts of interest, a resource that is very useful. Fry Vogel on conflicts, given that to you for your information and reference. Criminal convictions. Every year, there are lawyers who are disciplined based upon the conviction of the lawyer for criminal offenses. The Kelsey case, a lawyer who was a high-ranking official in the General Assembly, pled guilty to 2 felonies involving conspiracy to defraud the United States and aiding and abetting in the acceptance of excessive contributions. Those were guilty plea. That was referred to the board to institute formal proceedings to determine the extent of final discipline. Disorderly conduct, the Liebrock case, that was sent to the board for whatever action the board may deem warranted. In other words, the board has discretion under the Supreme Court's order to determine if any action, what if any action is needed for this, as to this misdemeanor conviction. The Harvey case, the Harvey case is a judge who pled guilty to DUI. Judge paid the associated fees. He the traffic charge of failing to stay in his lane was dismissed. He was placed on supervised probation for 11 months, 29 days. As with many first offense DUIs, he was prohibited from driving for 1 year, required to forfeit his handgun, suspended 11 months, 29 days, except for 48 hours served in jail. The judge, following his arrest, contacted TLAP and proactively contacted disciplinary counsel for the Board of Judicial Conduct, checked himself into an inpatient facility and went through 60 days of inpatient treatment for alcoholism, entered into a monitoring agreement with TLAP. The Board of Judicial Conduct suspended the judge from office for 30 days, ordered that he adhere to the recommendations consistent with the monitoring agreement for 5 years. This Gutierrez case, a lawyer, plaintiff's attorney who was disbarred during the criminal proceeding, pendency of the criminal proceedings. He was convicted, sentenced to 30 months imprisonment, followed by 3 years of supervised release and $147,000 plus in restitution. The Sixth Circuit affirmed. He was a former football player and tried to raise CTE as a potential defense. That was rejected. He was taking money that belonged to clients from the trust account and converting them to his personal use. Criminal law, the Stegall case, lawyer appealed the client's conviction, but failed to file the trial transcript or seek an extension. He received a public censure. The disciplinary process. Every year, several lawyers are temporarily suspended for failing to respond to the board concerning a disciplinary complaint. A disciplinary complaint can be a paralyzing event, but one of the worst mistakes a lawyer can make is to not respond to disciplinary counsel. Disciplinary counsel will grant an extension and in many instances will grant multiple extensions for if good reason is shown. But if disciplinary counsel does not hear from the lawyer, then disciplinary counsel will submit an order of temporary suspension to the Tennessee Supreme Court. When that happens and the court signs the order, the lawyer is not going to be able to practice law until he or she, let's say it together, files a response to the disciplinary complaint. And again, whenever a disciplinary complaint is received, best practice is to retain a lawyer to assist you in defending the disciplinary complaint, or consult with a trusted colleague, even if the lawyer chooses not to formally retain the colleague, but simply responding oneself, acting totally pro se, has on multiple occasions become problematic for a respondent attorney. Misappropriation. There are 2 cases where lawyers were suspended for misappropriating client funds. The shoe card case, it was a lawyer acted. It was very unusual behavior during a disciplinary proceeding before a hearing panel. The lawyer became agitated, very upset, was not reasoning properly, and there was real concern that the lawyer was a threat of harm to the public. Temporarily suspended, filed a petition to dissolve the temporary suspension. The quotes you can look at if you're so inclined, but the Supreme Court said, you know, you're still doing what caused us in the first place to temporarily suspend you. So the temporary suspension remains in effect. The Tennessee Supreme Court rejected an enforcement of a hearing panel's decision suspending a lawyer for 1 year, and changed the discipline to no less than 90 days active, the remainder on conditional probation. This is mentioned because the Tennessee Supreme Court reviews the discipline that is imposed after a hearing panel proceeding. They want to make sure the discipline is meted out in a proportional basis. In this instance, discipline went down. We will hear about a case in a few minutes where discipline was increased. So the Supreme Court takes its obligation as being the final disciplinary authority in this state very seriously, and it will not, several times a year, it seems, they send out an order that says, we deem the discipline imposed to be inadequate and propose to increase it. So again, the Tennessee Supreme Court is very active in the actual amount of discipline imposed. The Finney case, a lawyer, about the time we convened last year, was suspended for 4 years, 3 years of which were active, the remainder on probation, failed to reasonably communicate with 2 clients the status of their respective cases. And a censure, the Richardson case, a lawyer sent a representation letter to an insurance company and responded to a request for information, but then did nothing else. So the lawyer received a public censure. File retention, the Judkins case, file retention. Remember that a lawyer cannot hold a file hostage from a client if the client needs the file for the ongoing matter. The file belongs to the client. The lawyer can copy the file if the lawyer wants or feels he or she needs the file for his or her records. There is a lien on the file under Tennessee law, but delivering the file to a client who has need of it for the ongoing matter does not waive or defeat the attorney's lien. The Judkins case, the lawyer asserted a lien. but he didn't immediately transfer the file to new counsel. Forging a client's signature or signing the client's name without the client's permission. This is one matter we discussed last year. The legal assistant prepared a forged final decree and letter without the lawyer's knowledge. So there were two problems there. One was the order that actually was submitted to the court. Second was the lawyer's failure to supervise his lawyer assistant having controls in place. Impaired lawyers and judges. A lawyer was temporarily suspended for failure to substantially comply with the TLAP monitoring agreement. Going to TLAP can be your best friend, or you can be the lawyer's worst enemy. And they do pay attention to their monitoring agreements and expect their clients to follow through and to abide by the obligations of a monitoring agreement. If not, TLAP can approach the Tennessee Supreme Court and ask that if discipline has been held in abeyance, that action be taken. We've already talked about the Harvey case. The judge who was convicted pled guilty to DUI and was suspended from judicial office for 30 days. A library resource mentioned it each year. Mental health and substance abuse information for Tennessee attorneys. It is available. It is a great resource if you are concerned about a colleague. Also provided in your handout information about TLAP Executive Director Buddy Stockwell and contact information. Essentially, since Mr. Stockwell has become the Executive Director, he has implemented safety-sensitive worker best practices as a means of diagnosing, treating, and monitoring licensed professionals. What the first inquiry is this lawyer fit for duty? It's a fitness for duty analysis. And again, there is a 24/7, 365 number. There are licensed healthcare professionals that are available. A person can call and not be obligated, can remain anonymous, basically. Making a call, if someone sees something and says something, can contact TLAP and inquire, is this, should we be concerned about this? Or we are concerned about this. What resources are available? Making a call to TLAP does not make the caller assume personal responsibility for the attorney who's the subject of the concern. And it does not require that TLAP inform the attorney if further action is taken, further contact is made, who contacted TLAP. This is extremely important. You may remember that it was not very many years ago, it was pre-COVID, but Tennessee had 8 lawyer suicides in the course of 9 months. And it was shattering. One of them was a very well-respected chancellor in Memphis, and steps had to be taken. There is an article that came out from the Washington Post, who did a poll survey, and being an attorney is the most stressful profession in the United States. So we're in a high stress profession. We knew that anyway. There are resources which are available. TLAP also, it's not limited to lawyers. A lawyer's family, immediate family, a spouse, or a child can also be provided assistance. Judicial discipline. Judges are getting disciplined. We've already talked about the Harvey case, where a judge pled guilty to DUI and was suspended for 30 days from judicial office. A judge received the Stokes case. A judge received a public reprimand for name calling a litigant in a hearing. The judge admitted calling the litigant a tough guy, telling him, "I hope you meet someone just like yourself one day." As he was leaving the courtroom, he acknowledged telling the litigant's daughter to shut up. The rest of the story was that the judge says that the litigant was rude and interrupted him. The daughter who was speaking was trying to explain her mother's disability, which caused her, through no fault of her own, to have erratic and uncontrollable arm movements. Judicial disqualification and recusal, pursuant to Rule 10B of the Tennessee rules of the Tennessee Supreme Court. This is an area where the court sets an expedited schedule and they hold their own feet to the fire. They abide by the expedited schedule. But the flip side of that is that they expect and require strict compliance with every one of the requirements in Rule 10B, both in the petition filed at the trial court and the contents of the appeal. The Haddix case is an example that a litigant did not comply with those requirements, which the court held were mandatory, and so they did not didn't provide a copy of the motion to recuse, the order denying it, or any other document filed in the trial court. And of course, the Court of Appeals says we can only make our decisions based upon what we have before us, and you don't provide it to us, we can't review it, your appeal is dismissed. The Bearden versus Ballad Health is repeating this again because it's just a good reminder of reasons not to disparage your opponent, especially in court filings. This case was a very experienced litigator, and literally said that the other side, the opposing party, had surrendered like Bataan to the Germans in World War I, opening the floodgates to France. One of the people on the other side, one of the party's officers, had a stutter, and he compared that individual to Porky Pig. And the Sixth Circuit dealt with this appeal on the merits, but then sent this very strong message. As a memo to the trial bar. Miscellaneous. We've already talked about the law being the most stressful profession. There's also, to me, I was struck by and I'm sorry, I can't show this to you in in full size. But there was a CLE this year, going to hold this up, on lawyer shaming. Legal ethics, the rule of law, equal access to justice. We have a problem in our profession of lawyer shaming, and to the extent that there are now CLEs on how to deal with lawyer shaming. To me, that's a wake-up call. Attorney-client privilege, something that we skipped over, and what I'm going to tell you about is something that did not happen. There's an unresolved legal issue as to what is the scope of attorney-client privilege when lawyers give both legal advice and non-legal advice. When that is mixed, is there privilege, or does the fact that non-legal advice was given, business advice, does that destroy attorney-client privilege? It was set to be argued before the U.S. Supreme Court last January. The issue was if one of the significant purposes behind the communication, then attorney-client privilege should prevail, even if most of the discussion was non-legal advice. That was the primary purpose test. The significant purpose test, which the competing position would expand the reach of privilege and therefore secrecy. The idea being that if illegal advice was a significant portion of the advice given, that the entire communication remains privileged. The Supreme Court decided to not hear this case, canceled oral argument, and so the issue is not resolved. But just be aware that that dual purpose issue of attorney-client privilege remains out there and is not resolved. Formal ethics opinion, Tennessee Formal Ethics Opinion 169 provides guidance as to the ethical obligation of departing attorneys and their former firms to notify clients of their options when an attorney leaves the firm. Many departures from firms are not amicable, putting it politely. They are abrupt. There are often disputes between the former firm and the lawyer. There are fights over files. Does the lawyer wants to come physically pick up all of the physical files and wants immediate access to all of the electronic files. The firm argues that you signed an agreement where all files belong to the firm and are property of the firm, both electronic and hard copy. This formal ethics opinion says that it puts the focus on the client. Departing lawyer and the law firm have an ethical duty to inform the client of the lawyer's departure. Why is that important? May I please, receptionist gets a call. May I please speak to Mr. Jones? Mr. Jones is no longer with the firm. Where can I get in touch with Mr. Jones? I can't give you that information. Well, and what's Mr. Jones' new address? Can't give you that information either. That is a frequent practice, and there are often very hard feelings both ways. The ethics opinion also says reminds us that the client has the right to select counsel of the client's choice. It is not possible for a lawyer to write a contract which says that the client will always be the client of lawyer Jones. As a matter of public policy in all 50 states, a client can terminate a lawyer for good reason, bad reason, no reason at all, on notice, and of course with the obligation to pay the lawyer for the services that the lawyer provided through the effective date of termination. So, and this opinion makes clear that the lawyer, that the notice should be given to the client by the departing lawyer, the law firm, or preferably jointly by the law firm and the lawyer. Board opinion 23-F-170 provides updated guidelines for an attorney's acceptance of credit card payments. Chief Disciplinary Counsel Sandy Garrett requested the board issue this opinion, and it says clearly that a lawyer can accept credit card payments, things such as PayPal, Venmo, or similar processing services, as long as the lawyer complies with the lawyer's obligations under the rules of professional conduct. The opinion states that a lawyer can pass on credit card fees to the client. It should be the amount that the firm pays. The lawyer has to take reasonable steps to avoid disclosure of information and confidential client information. That means that privacy settings have to be taken care of, and the lawyer should always select the most secure privacy setting provided by the credit card company. The lawyer also has to deal with chargeback rights, and particularly during pending resolution of a dispute with the credit card company. The credit card company, in many instances, has a contractual right to access the lawyer's account to debit funds that were previously deposited into the account and charge it back to the cardholder. That especially creates problems for monies that are deposited into a lawyer's trust account. So again, credit card payments are permitted, but there are steps that have to be taken to protect the rights of clients and preserve confidentiality. The ABA Standing Committee on Ethics and Professional Responsibility issues formal ethics opinions. This year is no exception. One that we mentioned last year, that just repeat it for your information, is reply all in electronic communications, and it's the problem of the multiple email thread, and a lawyer hits reply all, and a recipient of that email is an individual on one of the other parties. And it's a communication directly with someone who is represented by a lawyer. So take a look at the summary, the synopsis of Ethics Opinion 503. It is sound advice. And again, we remind you that ABA formal ethics opinions are not binding in Tennessee just because they've been issued by the ABA, unless the Board of Professional Responsibility or the Tennessee Supreme Court adopts or ratifies the opinion. But they are very helpful reference tools on issues on which the Tennessee Supreme Court or the Board of Professional Responsibility have not opined. Formal Opinion 504 dealt with choice of law, and the question is, when a lawyer is practicing in multiple jurisdictions, which state's ethics rules control? The question is, if you're practicing in front of a tribunal in another state, that state's rules you'll be subject to that state's jurisdiction, including for ethics issues. And sometimes it's not clear. Discussed several factors relevant to determining the predominant effect of the representation. It could be a contract, it could be a transaction, it may not be an adjudicative matter, but again, these are the factors that are considered in determining which state has the predominant effect on the underlying matter. Formal Opinion 505, attorney's fees, retainers, we've already discussed that. 506, responsibilities over non-lawyer legal assistance, client intake. And again, when someone is being met with by a staff member for client intake purposes, the individual may believe that he or she is talking with a lawyer. That cannot be allowed to remain or be considered. That person has a right as a staff member to give legal advice, or that what the individual says to the client is an agreement that binds the lawyer or the law firm. It's very important. It's very important that lawyers and law firms train, including very experienced professionals, as to the parameters of what non-lawyer assistants can and cannot do, and they're on the front lines. These people are the ones who get the phone calls more often than not, because the lawyer is in a transactional closing, or in a meeting, or in a deposition, or at a hearing, or in trial. But this has just as much effect on non-litigator staff as it does litigation staff. Persons who prepare work for professional lawyers who prepare tax returns or do probate work. Those things, again, those issues are regular, ongoing, and it's important that lawyers periodically, regularly stop and train or retrain non-lawyer assistants. Office sharing arrangements, 2 new resources for as to the ethical considerations arising from office sharing arrangements. Problems have arisen, and finally some guidance has been created. You can see at the bottom of page 11, top of page 12, Steve Christopher, who's the Deputy Chief Counsel for the board in charge of investigations, wrote an article in Board Notes, the fall 2023 edition. This is a very helpful online magazine, It's available on the board website free of charge if you don't get it, and you can subscribe to it by email. There are a couple of articles. There's always an article or more that provide important information to Tennessee lawyers. Mr. Christopher wrote this article on the ethical concerns for lawyers practicing in office sharing arrangements. If you know what is the office sharing arrangement? If is it 5 lawyers? Well, if they work together and they share fees, they may be deemed a law firm and have to take the steps for management that are required of firms. If it's 5 individual lawyers, then there are considerations that don't affect firms. What about the common fax machine? What about the common computer server? What about if, hey, can I kick this problem around with you? Well, if the group is a firm, there is no confidentiality consideration because it's a firm and they're discussing a firm client. But if it's a group of lawyers sharing space, and it's merely an association of individual attorneys, they can still have the conversation as long as steps are taken not to disclose the identity of the client whose matter is being discussed. But again, those protocols have to be followed. Same thing with shared staff. And also running conflicts checks on matters. Personal security, electronic security, phishing emails. It is very important. It's very important to be alert to phishing emails. Regularly we hear of lawyers who have lost money from his or her or the firm's trust account, and it turns out that there's a penetration or an email was responded to. It's a 1-digit difference. Be very careful in wiring funds. It is far better if the email does not look right to stop and verify rather than send, even if it means that the transaction is completed the next day. The losses are usually very substantial, and of course, it causes your trust account balance to be short. Remember a couple of things. A couple of years ago, one of the schemes was your bar complaint. That would get an instant click from a receiving attorney. A logo often appeared. Georgia, North Carolina, Mississippi actually put out alerts saying, we do not contact, the first contact about a bar complaint is never by email. The same holds true for the Internal Revenue Service. The logo may appear, but the IRS never makes the initial contact by email. And in fact, they post warnings on their website at www.irs.gov. Please be careful on emails and on wiring funds. Real estate, a very helpful article from Mr. Christopher again. Ethical issues in handling residential real estate closings. The chances for conflicts are very real in a real estate transaction due to the multiplicity of parties. So who is the client? Is a particular event? Is it providing legal services? This is a helpful article for which you may want to spend some time checking out. And as we close out the trust and trust accounting, please remember the Lawyer's Trust Accounting Handbook, written by Sandy Garrett. It's been adopted or used by other states. It is the source reference for trust accounting. It starts out with how to balance your trust account. And again, the flip side of that is that the board has very little tolerance or zero tolerance for a trust account being out of balance. This resource is there, and the idea of, oh, we didn't know, does not travel very far with disciplinary counsel. Disciplinary counsel also expects the lawyers and law firms to take reasonable steps to make sure that their computer systems are properly maintained. A computer crash for any ethical matter, a computer crash is only going to carry one so far in terms of an explanation. So being current with technology, making sure that this does not mean that every year you've got to buy state-of-the-art things. It does mean that you do have to have reasonable technology based upon what life in 2023 and upcoming early 24. Finally, the Wagner case, Tennessee Supreme Court decision. A lawyer violated Rule 5.5A and wound up being suspended. A hearing panel suspended him for 4 years with 1 year active. There was a change by the trial court on appeal, and it went to the Tennessee Supreme Court. This is a really important decision. The lawyer wound up being suspended by the Tennessee Supreme Court for 2 years, 18 months, 18 months active. The ordered to make restitution. While the lawyer was suspended, the lawyer continued to manage and market his law practice. He directly or indirectly communicated with office staff, including his office manager. He hired lawyers and recruited attorneys while his license was suspended, and also talked to former clients while he was suspended. He was trying to keep the business going and growing while his law license was suspended. His defense was, I wasn't practicing law. The Tennessee Supreme Court disagreed and ordered him suspended for 2 years. One of the more telling events in West in the history of this ethics seminar was I was presenting on the first managing partner of a law firm to be suspended, and also someone who was practicing during a suspension. And the booming voice of Jesse Joseph, one of the disciplinary counsel at that time, said, "Bruce, if you're suspended from the practice of law, you can't empty a wastebasket in a law office." That comes close. So here the lawyer did way too much while the lawyer was suspended and wound up being disciplined. So I have gone 3 minutes over. I apologize, Laura, and thank you all for your attention. If anyone has any questions, or wants to discuss anything, please email me. My contact information, or call me. My contact information is at the head of the handout. Thank you.
Great. Thanks so much, Bruce. We'll now take our break that we have to take, and we'll be back at 2:15 for the last presentation. All right, everybody, it's 2:15, so we'll go ahead and get started. Laura, you can go ahead.
All right. For those of you who don't know, I'm Ethics Counsel for the Board of Professional Responsibility. And what that entails is mostly answering the phone and answering ethics calls for lawyers. And while I've been doing that, I can tell you that in recent months, it seems to me that lawyers are becoming more and more stressed. And it was interesting that I usually bring you ethics updates from the board, but Andy asked me this time to talk about wellness. And so that's what I'm going to be talking about today, is attorney wellness. Bruce told me that he had already talked to you about this Washington Post article about being a lawyer is the most stressful occupation in the US, according to this analysis by the Washington Post that used data from the US Bureau of Labor Statistics. And they looked at data collected in 4 American Time use surveys between 2010 and 2021. And the surveys asked respondents how meaningful their activities were, or how happy, sad, stressed, pain, or tired they felt on a 6-point scale. The industry with the lowest levels of self-reported happiness, with the highest levels of self-reported happiness, was agriculture, logging, and forestry. Obviously, these do not involve interaction with a lot of people like lawyers have. I just read an article that said 2022 was the highest year of suicide ever recorded in America. And this was done with data from the CDC. The CDC put this out and said that 2002 was the highest year of reported suicide ever recorded in America. And I recently found a Bar Journal article that was written by Buddy Stockwell. I don't know how many of you know who Buddy is, but he is the director of TLAP now. And he has done a phenomenal job. And he wrote an article for the Tennessee Bar Journal on lawyer suicide. And he starts out with a sentence that says, suicides continue to devastate our legal profession here in Tennessee. And I think it's probably nationwide. And the truth is that we in the legal profession are at greater risk for suicide than those in the general population, simply because we suffer such high rates of depression and substance abuse disorders. So he went on in the article to say that self-care is critically important. In other words, taking care of yourself in today's fast-paced profession. And if we're to deal with the rates of mental health issues and suicide, then our culture must include and mandate self-care. I think maybe that's happening. I'll tell you later about some states that are requiring wellness as a mandated CLE. For reducing suicide, self-care is important, but we also have to care for our peers who may be suffering, especially those at risk for suicide. And this is what Buddy says. In his article, he says the Texas Lawyers Assistance Program recently produced a very powerful video centered on trying to reduce suicide. The title says it all. Just ask how we must stop minding our own business in the legal world. And this has to do with helping out others. And you can see that video. It's on YouTube. Just put that title into Google. Just ask how we must stop minding our own business in the legal world. He highly suggest that we look at those. And he sets out some of the suicide warning signs that you may not recognize about people sitting around you or working with you. But if you see people that are experiencing feelings of hopelessness, saying they have no reason to live, feeling being trapped or in unbearable pain or a burden to others, that's something that is a definite warning sign. He also said to beware of behavior that includes increased use of alcohol or drugs, being anxious, being agitated or reckless, sleeping too little or too much, withdrawing or isolating from others, showing rage or talking about seeking revenge, or displaying extreme mood signs or swings, extreme mood swings. So these are things that you would notice about people around you. And he said, myths and misunderstandings about suicide still abound. And he said, one highly prevalent myth is that if someone is going to commit suicide, there's nothing anyone can do to stop them. And he says, on the contrary, suicide is considered one of the most preventable causes of death. The bottom line is we do not have to be mental health professionals to make a difference. And so you may need to reach out to someone, or you may need to reach out to TLAP. And at the end of the program, there's a contact sheet that has TLAP's number. And you can anonymously report somebody to TLAP that needs help or that you think needs help, and TLAP will step in. You don't have to give your name. You can just tell them that this person is exhibiting signs of suicide or substance abuse or those type of things. And they are very helpful. So you might say, well, is this an ethics issue? Is suicide or mental health issues, are those ethics issues? And they definitely are, because here are 3 rules that really apply to someone that is having a mental health crisis or substance abuse problems. Competence, for one thing. If you are under the influence or you are so upset by something, you don't have time to be competent as a lawyer. As you know, competence requires research and study, and people that are having these problems just don't have the time or the want to do that. And then diligence. This is something, as you may know, 50% of all the complaints we get have to do with diligence and communication with the client. So this is something that can really be affected if someone is having health issues, mental health issues, or substance abuse problems. And then rule 5.1 is about your supervisory obligations to lawyers that you supervise. And certainly you couldn't be doing that very well if you're yourself having a problem. And then rule 5.3 talks about supervising your non-lawyer assistants or people that work in your office that aren't lawyers. And you have to be an example for them, and you have to make sure that you have rules and policies in place to make sure that they are complying with the rules of professional conduct. So that's very hard to do if you yourself are having mental health issues. In 2015, the American Bar Association did a study of 13,000 attorneys, and they found that 32% of those attorneys under the age of 30 reported having a drinking problem, as compared to 21% of attorneys overall and 6.5% of the general US population over the age of 25. These numbers were bad before COVID, and what the bar is seeing is that attorney stress is at all-time levels. More than 3/4 of lawyers have thought about leaving their jobs or the legal profession for that reason, or because of stress in the last 3 years. In other words, people are just burned out at what they're doing. And so the American Bar Association formally recognized in 2018 that this was a problem, that attorney wellness was an ethics issue, and it called for concerted action aimed at reducing the incident and impact of mental health and substance abuse problems in the legal profession. And I just recently read this article, ABA Wellbeing Pledge turns 5, progress made, progress needed. So this fall marked the 5th year anniversary of the ABA Wellbeing Pledge. And you wonder, well, what is that? It was a campaign that was launched to improve substance abuse and mental health landscape of the legal profession, with an emphasis on helping legal employers to support a healthy and sustainable work environment. The primary vehicle for this campaign was a pledge that called for these employers, including the judiciary, law firms, law schools, corporate entities, government agencies, and legal aid organizations to take this pledge to recognize that substance abuse and mental health issues represent a significant challenge to the legal profession, and then try to support and prioritize the pledge's 7-point framework for building a better future. The mission there was to reduce the incident of problematic substance use and mental health distress and challenge the stigma surrounding those issues and improve the overall well-being of the legal community. Here is the pledge itself. Recognizing that high levels of problematic substance use and mental health distress present a significant challenge for the legal community, and acknowledging that more can and should be done to improve the health and well-being of those in the legal community, including judges, lawyers, staff, and students, we, and then there's the blank, the law firm or the business or whatever, pledge our support for this innovative campaign, and will work to adopt and prioritize its 7-point framework for building a better future. And then they set out 7 steps. The 7, excuse me. I'm so sorry. This is the first step. Just a minute. I'm so sorry. Okay, so the first step was to provide enhanced and robust education to everyone in the organization, including judges, lawyers, staff, and students, on topics related to well-being, mental health, and substance abuse or substance use disorders. The second step for these businesses was to disrupt the status quo of drinking-based events, challenge the expectations that all events include alcohol, seek creative alternatives, and ensure that there are always appealing non-alcoholic alternatives when alcohol is served. Point 3, develop visible partnerships with outside resources committed to reducing substance use disorders and mental health distress in the legal community. In other words, healthcare insurers, lawyers' assistance programs, and experts in the field. And that's where Buddy Stockwell and TLAP come in. Number 4, provide confidential access to addiction and mental health experts and resources, including free, in-house, and self-assessment tools. Number 5, develop proactive policies and protocols to support assessment and treatment of substance use and mental health problems, including a defined back to work or school policy following treatment. Point 6, actively and consistently demonstrate that help seeking and self-care are core cultural values. How do they do that? By regularly supporting programs to improve physical and mental and emotional well-being. And finally, point 7 is to highlight the adoption of this well-being framework to attract and retain the best individuals in the organization, including judges, lawyers, staff, and students. At this time, a total of 227 current signatories are to the pledge. The workplaces of tens of thousands of lawyers have now committed to taking specific concrete steps to raise awareness and reduce risks. Well, what about solo or small firms? I think we could pledge to look out for our own well-being and pledge to look out for the well-being of your colleagues in the Tennessee legal community. Well, how do I do that? First of all, I think we have to acknowledge that and understand that the world in which we are operating after the pandemic is different than it was before the pandemic. American workers are reporting that they are the most unhappy they've been in years, despite wage increases, more paid time off, and greater control over where they work, per the Wall Street Journal. A Gallup workplace report from 2023 found the number of US workers say they are angry, stressed, and disengaged. The number of those is climbing. Another study found similarly that data from more than 57,000 workers show job satisfaction scores have fallen to the lowest point since early 2020. In other words, right before the pandemic, after a 10% drop this year alone. So I don't know what the pandemic did, but it has certainly changed the whole landscape of the legal profession. The new world of remote work. Lots of people are still working remotely or choosing to work remotely. I know several law firms that went completely remote. They don't have an office, and they talk to their assistants remotely by computer, by phone. And this is something that's caused prominent concerns, two of which are isolation and burnout. Isolation causes loneliness, and that's a potential setback for remote work, especially if you're not getting much social interaction from your friends and family or elsewhere in your personal life. So I think we can make an effort to socialize more with colleagues. Try to do that if you're working remotely. And then getting serious about legal burnout and how to identify it. According to the Mayo Clinic, some signs are becoming highly cynical or critical, difficulty focusing, feeling disillusioned or dissatisfied at your job, exhaustion, insomnia, stomach or bowel problems, changes in appetite, or frequent headaches. So how do we avoid burnout? And these are suggestions from the ABA. One is the need to set clear work boundaries, particularly if you are working remotely. Set times to turn off email notifications. How many of you take your cell phone home with you and take calls from your clients? You're not setting any kind of a clear boundary if you're doing that. I have a boss that does that. I don't know how she stands it, but she can't ever turn off her email or her phone notifications. So I think that if you set times to turn it off so that you can disengage for a little bit from the stress, that is so important. If you're working remotely, create a dedicated workspace in your house that's the only place that you work. And then set regular business hours. It's been proven that people that are working remotely are actually working more hours than they do at work because they think of something and they go do something with it at their workstation. Don't do that. Set your regular business hours just like you were going to the office. This is the big one. And I think this is whether you're in an office, whether you're doing it remotely, whatever you're doing, manage your client expectations. Give yourself time off not to check email. So you can set expectations with your clients and your colleagues about your off hours and days and times you will be unavailable. And the best time to do this is when you first meet the client the first time. When you sit down and talk with the client, have them sign your engagement letter or whatever, you need to tell them there are times that I am not available. I work this time to this time. And unless it's an emergency, I don't want to hear from you because I'm not going to be having my email on. And then how do you recover from work stress according to science? To combat stress and burnout, employers are increasingly offering benefits like virtual mental health support, flexible work scheduling, spontaneous days off. But despite these efforts, the workforce is tired. Only 32% of employees across the board say they are thriving. 43% report high levels of daily stress. Some reports have up to 61% of US professionals feeling like they're on the edge of burnout at any time. Some ways to manage this is set aside time to examine whether you are exhibiting any of these signs of occupational burnout. Then 2, make a decision to take charge of all aspects of your life. Consider where you would adopt more productive lifestyle habits. Investigate and take advantage of all available resources. So, if you look at these things, first of all, determine whether you are exhibiting signs of burnout. A lot of people don't have to really set aside time to examine that because they know they are on the edge of it or are burned out. I personally have a friend who's for 8 years been telling me they're burned out. So I'm thinking they're getting ready to retire. But the point is, figure out if you are doing this to yourself and then make a decision that you're not going to do that. You're going to take charge of your life. And then consider where you could adopt more productive lifestyle habits, such as what we were talking about, turning off your cell phone at times, getting away from work, investigating and taking advantage of available resources. I talked about the ABA and their pledge. They also have all sorts of resources for people that are trying to escape burnout. They have a toolkit that's free. You can go to their website and see that. Number one thing is to detach psychologically from work. It's important to mentally disconnect or switch off your work, and your work thoughts, your work time. You could be physically present at your exercise class and your mind's replaying the events of an earlier client meeting. The exercise class is probably not going to do you 100% good because you're psychologically still stressed out from whatever you're replaying in your mind. So research shows that even thinking about work detracts from your ability to recover from it. Give your mind a break. Do something that will make you not think about your work. That may be the hardest thing to do, is detaching psychologically from your work. And then harness the power of micro breaks during the workday. Common assumption is that recovery can only happen after work or during a long holiday or whatever, but research has shown that micro breaks, short breaks, approximately 10 minutes during the workday, are surprisingly effective for recovering from daily work stress and various job demands. So get up from your computer, get up from whatever you're doing, take a walk around the office, Go outside, walk around the block, do something for a very short time, and try not to think about work for 10 minutes. That is surprisingly helpful. And then consider your preference for recovery activity. You know, you need to do something active, but here's the thing. If you are doing something somebody else wants to do, and it's not something you like, that's really not going to help. The author of these tips says, I used to partake in my partner's hobby during my free time so we could spend quality time together. And then I realized that I did not like, and I dreaded going to guitar lessons. So now we have our own hobbies. I do my gardening while my partner learns guitar, and we carve out time to spend together afterwards. Be mindful how you use your lunch breaks. That's another thing. Those are free slots of time that you can use for recovery activities that you prefer. Just happens that the building that I'm in has a gym, and many people from this office during their lunch hour go there and do some exercise. That's very helpful. Can't say that I do that, but I figured I will do something else. Prioritize high effort recovery activities. And it might seem that relaxing in front of TV or passive low effort activities are best for recovery, but research has shown, on the contrary, that more active activities can even be more effective for recovery. A senior executive of a multinational healthcare company said, I may not be rah-rah about it ahead of time, but there's never been a gym session I regretted afterwards. So if you don't enjoy going to the gym or playing team sports, you can find an exercise that you can enjoy, such as a fast walk, a hike, or a swim. In my case, I love horseback riding. There's just nothing like that, getting out. And I really can shut off my mind with regard to work when I do that. Shape your environment for optimal recovery. That's the 5th tip here. Research on direct exposure to nature, such as park walks during workday lunch breaks, shows that it can enhance your recovery from stress in as little as 10 minutes. You don't need to book a trip to the mountains. You can stay connected to nature while at work by using any outdoor facilities your employer provides, like cafeteria terraces, green spaces at building entries, or just taking short walks outside. Just getting out in the fresh air itself makes a big difference. Here are some other tips for living in this divisive world that we're living in right now. And this is something that I saw on the internet that I thought was so helpful. Make kindness the norm. Send an uplifting text to a friend or family member. You may not think to do that, but when you do that and they are happy, or it makes them happy, they usually text something back and it will make you happy. This is a big one. Let the guy merge into traffic ahead of you. How many times are people just all over the road? This picture just is like Nashville traffic for sure. But somehow, if you will just let calm sweep over you and let somebody merge in ahead of you, they're always thankful that you did, and it will make you feel better, actually. Include intentional moments of kindness, laughter, and delight in your daily routine. Share a joke with a colleague. At least once a day. I have a very good friend at work, and we just talk about stuff going on in our life, not to do with work. And, you know, it usually involves laughter and maybe joking, and it's just makes you feel better, even if it's just a short few moments. Go outside your comfort zone at least once a day to make someone smile. Be the reason somebody smiles today. And then share a compliment with a coworker or a friend. You know, that is so helpful to people. if they do a good job, somebody in your office, give them a compliment. It makes them feel better and they think better of you and you think better of yourself, actually. Reach out to a family member or a friend you haven't spoken to for a while. This will probably make you happy and make them happy too. And then here's the last one, and the one I like the best because this recently happened to me. Treat someone to a cup of coffee, a friend, a stranger, or even yourself. I was at the drive-through line to pick up a cup of coffee, and the woman opened the window and said, "Oh, you don't need to pay today. The man ahead of you just paid for your coffee." That made me feel so good. And I just immediately said, "Well, I'm going to pay for the person behind me." And she says, "Well, their bill's $8. I said, "I don't care. I just want to do it." And it just made me feel so good. So try that one time. It's really uplifting. Remember the Washington Post article that Bruce talked about and the one that I showed you? The industry with the lowest reported levels of stress and highest levels of self-reported happiness is agriculture, logging, and forestry. That should tell us something. Get some time outdoors in nature. This is a really important thing. So try to go for a walk outside or spend some time on the weekend, maybe going to a park for a hike with a friend. Those type of things will make you feel so much better. This is a big one for me. Vitamin D from the sun is a mood lifter. I don't know if any of you know, but about a year ago, I had a hip replacement and I was in so much pain and I was on pain pills for seemed like forever. And I took a trip to Key West and I got out in the sun. And after 3 days, I was not taking any pain pills at all. I don't know how that vitamin D worked, but after that, it just totally got better. I'm just telling you, there's something about the sun that will lift your mood and actually heal your body, I think. But I'm not professing to be a doctor, but that's something that I really believe in. Studies have shown that interaction with pets helps get rid of stress. Guess what? These guys do not judge you, and they're always happy to see you. And I read a Japanese scientist found in a study that he did in Japan that people over 65 who own a dog are 40% less likely to develop Alzheimer's or dementia. Now, isn't that weird? 40% less likely to develop dementia. Makes me think maybe I need to be getting a dog. The importance of movement. Research consistently confirms that daily movement is key for maintaining mental well-being. A 2020 study by the University of Vermont found that 20 minutes of aerobic exercise has immediate positive effects on your mood and can last for 12 hours. Many attorneys have found that short walks in the outdoors helps put them in a positive frame of mind. So keep that in mind. So there are benefits for devising and enacting an intentional recovery plan. Remember back, we're going to decide if we need recovery because we're feeling burnout. Well, recovery can sustain your energy and well-being and positive on your moods. And recovery can sustain motivation and boost cognitive and physical performance. And recovery can boost your overall life satisfaction. By following these strategies that we've just talked about for recovery, you can better create and enact an intentional recovery plan to sustain your energy and performance over time. But remember, when you need to recover is when you're most least likely to engage in these recovery activities. So if you are feeling like you need to recover, you're having a burnout situation, you're having a mental health crisis, that's when you need to remember to do these things. And it's becoming so important that some jurisdictions, like I said, are requiring wellness or substance abuse CLE hours. Nevada, Illinois, North Carolina, South Carolina, and Vermont have all said to their attorneys, part of your mandatory ethics CLE needs to be in wellness or substance abuse. I wanted to read you a story to end today's CLE. I know I'm not near the end, but the story takes a while, so bear with me. The story is called Making It Back. Bruce Simpson tried to take his own life, then he started healing. And this is his story. I have practiced law in Kentucky for 40 years, and I write this today to warn you about reaching the point of no return should you ever determine, as I did in January 2023, that death is a better option than life. Yes, I attempted suicide. Now the facts. During the last half of my career, I heard it said, Bruce, you have an excellent reputation as a lawyer. I cherished hearing those words. My self-worth became increasingly dependent on receiving such positive affirmation. This is because I've had a low self-esteem for most of my life. I mask it well, but beginning in early adolescence, I suffered from untreated and sometimes paralyzing depression, a problem I did not recognize, appreciate, or obtain treatment for until after my significant life crisis in January 2023. I was in my mid-40s before I began to feel better about myself, but that was only because I started experiencing major success as a lawyer. In early 2022, doctors diagnosed me with atrial fibrillation, which required hospitalization. In May 2022, I suffered a brain bleed, hemorrhagic stroke, from a fall and was hospitalized 4 times during the next 7 months. The brain bleed exacerbated a pre-existing cognitive memory impairment related to my depression that I did not know I had until it was too late. In January 2023, I received a shocking adverse decision from an appellate court that noted I had not filed a responsive brief in a case I won at the trial court level. Instantly, I was crushed by more anxiety than I knew could exist. How could I not have filed a brief in the case I won? I could not believe I hurt my clients, and I saw my excellent reputation disintegrate. I was up all night, overcome with grief, sorrow, and humiliation. In less than 12 hours, I concluded that suicide was my only option. I had previously thought about suicide should my self-esteem ever seriously be threatened. I had to be perfect as a lawyer, and anything less was unacceptable. I never took any steps to ameliorate my depression and thoughts of suicide. Such is the nature of depression. A person suffering from depression is often constrained from seeking help. I went to a gun shop to buy a powerful pistol. I had not fired a weapon since serving 2 years in the Army 50 years ago. I knew of people who failed in their suicide attempts by gun only to live out their days in tortured agony and dependency. I did not want this. I was advised to purchase a 35.357 Magnum revolver and hollow point bullets. As I was shown how to load and fire the gun, I paid close attention. I intended to be successful. Then I went home and wrote a note to my family. I love my family, but I thought I had disgraced them and myself beyond restoration. I emailed my clients advising them of the appellate court decision and their appeal rights. I also recommended that they retain new counsel, but I did not tell them what I was going to do. I took an Uber to the cemetery where my grandparents are buried. Before exiting the Uber, I texted a partner, advised him of my error, and apologized. I milled around the cemetery, pausing momentarily before pulling out the gun. Alone, I thought, really, Simpson, is this how you want your life to end? Is this how you want to be remembered? My cell phone started blowing up with calls. My wife clearly had found my note. I turned off my phone. I did not want to be dissuaded. I had reached the point of no return. I wondered if the gun would fire, so I test fired a round into the ground. I was stunned by the loudness and kickback. I knew the shot would attract attention, so I called 911 and reported that I had discovered a body. I removed the spent shell and then pulled the hammer back from the pistol, watching the next bullet rotate into the firing chamber like the previous bullet did during the test firing. I pointed the gun to the side of my head and I pulled the trigger. But the gun did not fire. It merely clicked. I was dumbfounded. I intended to kill myself. What happened? I knew the police would arrive soon and I did not want to shoot myself while an officer was approaching, so I put the gun in my pocket. The officer drove up, stopping next to me. I told him I was wrong about the body, that was a garbage bag. He said, "No problem. Thanks for reporting it anyway." He drove away. Totally bewildered, I walked out of the cemetery. A thought entered my mind to call a former close friend, Bruce Smith, and it's not our Bruce Smith, I'm sure, but this person was also an attorney. We had been friends for years, but we had two hotly contested cases opposite each other, and the relationship soured. I had not thought about calling him in 5 years. If he did not answer, I would return to the cemetery and finish it, but he answered and he agreed to talk. He picked me up and we went to a bar. We talked for 2.5 hours and healed our friendship. Nevertheless, I was still determined to return to the cemetery and kill myself. I never disclosed this to Bruce. When it came time to leave, I asked Bruce to drop me off at a gas station across from the cemetery, and I would wait for an Uber. As he departed his car, he asked, "Where are you going?" I told him to wait for an Uber. He said, "No, it's cold. I'll wait with you." I said, "No, go ahead. It's late." He said, "I'm waiting with you." I attempted to leave his car 3 times that night for the cemetery, and each time he stopped me. He subsequently took me home. Driving down my street toward my house, we observed 5 or 6 police cars. Bruce looked at me and demanded, "What the hell is going on?" I muttered something ridiculously unbelievable. I asked him to drive me to the main road 2 miles away. As I finally left his car, Bruce grabbed my arm and said, "You're going home, right?" And again, I said yes. I still intended to kill myself, but after leaving his car, I had a sudden change in thinking. I could not kill myself after he had driven 12 miles to take me home. I could not leave Bruce with that memory. As I walked home, I experienced an enveloping sense of peace, in stark contrast to the nightmarish distress that had consumed me. My suicidal thoughts abated. Approaching my home, I noticed the police cars were gone. I telephoned my wife. She was ecstatic. She bolted out the front door crying and hugged me. She was elated and devastated at the same time. My wife called the police, advising them of my return. Shortly, 2 police cars and a paramedic unit appeared. I told them my desire for suicide had ceased, but a police officer said that because of my threatened action, I would be detained for 3 days at Eastern State Hospital. My gun was confiscated. A police officer searched me for other weapons and then escorted me outside. I was handcuffed and lodged in the back seat of a cruiser, all in front of my home and neighbors. En route to the hospital, I recalled my past inappropriate comments about people in mental hospitals. I was put in an unlocked room and checked on every 15 minutes. Staff had to unlock the restroom when I needed to use it and be in the bathroom while I showered. I was truthful in my responses to all questions, but I did not volunteer that I pulled the trigger or that I tried multiple times that night to finish my mission. I was afraid if I told them this, they might confine me longer than 3 days. I shared only that I had changed my mind about suicide. During my stay at Eastern State Hospital, a clinical psychologist, Dr. Donald Crow, helped me understand that my self-worth should be based on who I am, not what I do in my profession. Through diagnostic testing, he discovered that I had a cognitive memory impairment. Physicians at the University of Kentucky later confirmed this, and they said my depression most likely caused the memory impairment. These physicians ruled out dementia and Alzheimer's disease. I learned that my memory problem could be substantially, if not totally, corrected with the healing of the brain bleed, appropriate medication, nutrition, and proper sleep. I have improved considerably and got progressively better. But for my involuntary commitment, I would never have gained this valuable insight and information. 10 days after my attempted suicide, I met with my clients. I apologized and informed them of their right to sue me and the statute of limitations. I still think about my mistake almost every day, but I'm no longer suicidal. Before this, I had been highly skeptical of counseling's efficacy. I was convinced that by sheer willpower, anyone could conquer what I thought was merely emotional problems. I was wrong. Competent counseling combined with appropriate medication is immensely helpful. My internist, Dr. Raghavan, my clinical psychologist, Dr. Seitz, and my nurse practitioner, Christy Carter, helped save my life. But too many people have prejudicial attitudes about those who need mental health. A stigma attaches to mental health treatment that does not attach to treatment for cancer, heart disease, and the like. Yet the pain and incapacity from being mentally overwhelmed can be as pernicious as any physical malady. And we readily acknowledged I have experienced both. As I started to heal, I began reading about suicide, its contributing risk factors, and its incidence. The threat of suicide is significant. The Centers for Disease Control and Prevention reports that suicide rates increased 36% between 2000 and 2018 and decreased 5% between 2018 and 2020. However, the rates returned to their peak in 2021. There were 48,183 suicides in the United States in 2021, or one death every 11 minutes. Lawyers are 2 to 3 times more likely to consider suicide than non-lawyers over 18. But why publicly share these intimate personal revelations, which may necessarily generate doubts about my fitness to practice a profession I love, especially since my memory and mental health have greatly improved? I have had 4 major hearings since January 25th, and I performed exceptionally well. I feel better mentally and think more clearly than I ever have. I have backup support from other attorneys with whom I co-counseled on every case. We divide the work, so there's no additional cost to the client. And that's why I'm sharing this. People are more vulnerable to being mentally shattered given certain life crises than they can sometimes appreciate. I do not want anyone I can influence, lawyer or not, to descend into an unstoppable spiral to the point of no return. I'm grateful to have another chance. Not everybody attempting suicide gets one. I have witnessed the wreckage a suicide attempt can have on one's family and friends. It is gut-wrenching. I can only imagine the horrific suffering of family members and friends of someone who dies by suicide. I did not realize the catastrophic impact suicide can have on others when I planned my own. We have one opportunity in life, and of course, and as miserable as it may get, such hardships can be mitigated and even remedied with assistance. Some of us may need more help than others. Our future can be better than our past. I'm experiencing it. We must stop whispering about suicide when we learn of someone's attempt. It should not be the subject of juicy gossip that must be immediately and secretly shared. This is harmful. On the contrary, I appreciated the few people who compassionately reached out to offer me support when they learned of my attempt. The data is compelling that suicide is an escalating public health problem. As a society, we must institute prompt and improved measures that address suicide prevention. Moreover, as a profession, if we proceed with the same ineffective response, what does this say about our concern for young people aspiring to be lawyers? We owe them and fellow attorneys of today more than what we are doing. We are killing ourselves at an alarming rate. Emergency assistance is available 24 hours a day via calling 988 in the Suicide and Crisis Lifeline. Help is also available via your state bar association's lawyer assistance program in Tennessee, that's TLAP. I do not know the answers. I have ideas. I'm available to listen and share with any lawyer contemplating suicide. I'm not a licensed counselor. I'm only a volunteer with the Kentucky Lawyer Assistance Program. But I am also someone who has been to the bottomless abyss of the darkest place. I am not sure I will ever be able to articulate with enough clarity the awfulness of the worst place any human being can venture. I do not want you to go there. There's a path forward that is not permeated with sadness or misery. Rewarding therapeutic help is available, and more importantly, it works. Please, for yourself, your family, your friends, reach out for it. And in that case, in our state, that is TLAP. So that was Bruce Simpson's story. He wrote it for the American Bar Journal this year, and I wanted to share that with you. And then what I want to leave you with are some wellness self-care tips for the holidays. You may think this is crazy, but I'm a state of Tennessee employee, and they sent all the state of Tennessee employees this little card with it has a little snowman on it and snowflakes, and it says, during the hustle and bustle of the holidays, remember, take care of you. And here's some holiday self-care tips. Find ways to relax. Go on a walk. Take time to read. Watch your favorite holiday movie. Try to find at least one way to relax each day. This is one I really like. Be okay with saying no, whether you're saying no to a gathering or a second helping or to taking a client. Remember, it's okay to say no to take care of yourself. When it comes to holiday foods, allow yourself to choose a favorite indulgence or two at a meal. Truly savor and enjoy the meal. And then the last one is make time for activity. Play an active game. Walk around the neighborhood to look at the lights. Did you know that physical activity can boost your immune system? And that was what the state of Tennessee sent out to the Tennessee lawyers that work here. So now we are at, oh, there it is right there. You can take a look at it. Now I put it on there. Now it's the time for questions. I don't see, well, I see maybe one in the chat. Nope, that's the link for credit for the CLE program. So I don't think there were any other questions. I want to go to this contact information because you will see that the Tennessee Lawyers Assistance Program is on there. And of course, the pictures of us, the presenters, is over the top of it, but that assistance program is 615-741-3238. And that is very important for yourself or for someone that you know is having a crisis. That would be very helpful. And so I guess 5 minutes early. Bruce or Lewis, do you have anything to add? Or are they gone? Hey, Bruce, you can always talk. Fill up the 5 minutes.
What Laura says is right on target. If you see something, say something. It's really important to, it's really important to be maybe a bit out of your comfort zone, but trying to help someone is infinitely better than the alternative. And it's surprising how many times a person's instincts are correct. one of the things that's striking about what Laura talked about is the instances where a small act or a, are you, how are you today? Or you look like you may be having a bad day, or you look down, or whatever, and it opens a wellspring from an individual. And believe me, it is not, oh geez, now I gotta listen to this person whine for and I've got things I got to get done, or I don't have time for this. That's not what this is about, and that's not what happens. So believe me, it is worth it. I have been in 7 interventions and I've led 4. Don't ask me my success rate, but what it has taught me is that you do not know how you can impact someone positively until you find yourself unwittingly or unintentionally, or because someone says, hey, this needs to be done and we want you or need you to do it. It's very much it's one of the best acts of kindness. It's important. And the other thing is that if you're in any group at all of any size in your office, it is amazing. Everyone has problems. It is amazing the people who you work with or you come in contact with, the person who hands the cup of coffee out the window each morning to you, the people in their lives and how they they're concerned about them. They have problems, and you have an opportunity to be a light or to be a help, and it's very, very important. Andy Cole deals with people who are in stress on a daily basis, where the needs are critical. That's part of what West Tennessee Legal Services does, and it's not just that individual. When the clients come in, almost always they are with other people, family members, concerned friends, and many times because the individual can't help themselves fully or need physical assistance in getting there. And so again, the well-being issue is not something to look out. I was working late one night, and a guy I saw all the time, we talked every night as he came to pick up the waste basket, and he said, boy, you guys just have it made, and you guys are just so you are just don't have a care in the world. I said, no, that's not true. That office, that individual had an adult daughter drop dead. That lawyer there, and he had dealt with severe debilitating depression. Another one that had 2 back-to-back deaths in her family. You do touch people's lives more than you realize, and taking an opportunity, even if it is just to, hey, happy holidays, good for you. That may be outside your normal comfort zone, but it can be extraordinarily helpful. And it may be that someone would say, hey, can I talk to you for a couple of minutes? And if that happens, please be gracious and give some of your time.
Thank you, Bruce. I knew you could fill up the time with really good thoughts. And those are good thoughts. I hope everybody have happy holidays and try to not be stressed out. I know it's a stressful time.
Great. Thanks, Laura. Thanks, Bruce. Thanks, Lewis. I was actually looking through my email because I know there was a recent, I think, TBA journal article about attorney well-being and suicide, but I can't find it. I want to think it's come out in the past month or past couple of weeks.
That was the article by
Buddy Stockwell.
Buddy Stockwell
that one?
part of, yes.
I didn't get a chance to read it yet, but I knew that it was in there. So, but everyone, the link for the CLE credit is in the chat. It's also in your email that had the link to join the Zoom. The materials are also in that email. If you have any questions, you can send me an email and I'll get anything to you. But thank you all for joining, and we'll see you again next year. Have a good day.
Thank you, everybody.
Bye-bye.
Bruce and Laura. Have a good weekend.